Now back to the show. This is The Law Show on CL 650.
Can I get a witness? Can I get a witness? Can I get a witness?
Can we get a witness? Well, we've got a couple of lawyers in studio, and that's always a great start. Little Marvin Gaye coming back to The Law Show here on CIL 650. Today, focusing on the importance of an updated will, a current valid will, with John Lakes and John White of Lakes White LLP in North Vancouver. Talking very fundamental stuff here with our two estate lawyers this morning. Basically, we asked all the fundamental question, what's a will, why is it so important? Let's start this round with John Lakes and why, or who. Who should have should we all have a will, given the fact that your partner here just identified that on any given day anywhere in Canada, a very small percentage of any of us will actually have a current valid working will. So first and foremost, John, the importance of that will and who should get it. At what point in your life does having a will become really important?
Well, technically, as soon as you turn 19, you should do a will, because that's when you're an adult and you acquire assets which wouldn't be covered by the public guardian or trust or whatever. But obviously, there's major times in your life that you should definitely do a will. First of all, when you start acquiring assets, when you marry, when you have children, when there's a death in the family that's unexpected, like a death of a child who may leave children, when you receive inheritance yourselves, when you start acquiring vacation property, if you immigrate from another country, because you might have a situation that, let's say, where you come from, they don't have the traditional wills like we have here. So you may want to cover situations for assets here. So I don't know. And the thing with wills too is you can have a will that's valid, that's 30 years old, that's currently current, and yet you could do a will 6 months ago where all of a sudden your life has drastically changed. You may have just one of those years that lots of things have happened. So if you have assets, you definitely should have a will. If you're married, you should have a will. If you have children, you should have a will, because one of the aspects in a will is not just assets for children, but also who's to be the guardian of your children as well.
Right.
Because if you don't have a will and you have assets, then the public guardian trustee may intervene, and there are government agencies that do the best they can. However, you know, they're a bureaucracy. They only work 5 days a week.
So is it reasonable to say, John, that if you don't have a will and you direct your affairs following your death, if you don't do it, the government will?
Well, no, it won't the government, but under the Wills, Estate and Succession Act, someone would have to apply to be administrator of their estate. So for example, I'm dealing with an estate right now where a woman died very suddenly, and she was divorced, and she had 2 children, and one's now 20 and one's 18, and we're sort of having to do things in limbo because there's things like mortgages that they want to keep the house till the youngest is 19, and there is an adult who's the administrator, but we have to make the bank happy so we can renew the mortgage, and these young girls are having to deal with stress with their mother dying anyway.
Of course, yeah.
But the fact is, without a will, there's always a certain degree of uncertainty, and therefore, you know, things do happen.
At least, though, in this circumstance, you are dealing with a will and following.
No, there's no will.
Oh, there isn't.
There is no will. So what happens is that each child will receive a fairly substantive check when they turn 19, which, you know, sometimes, you know, if you give people a lot of money at 19, it could be gone pretty quickly.
True.
And so if you have children, quite often people will have money tied up till the child's 25 or 30 or whatever. But and then if you've got a child with a disability, for example, who's not competent, then that money is going to go directly to the public guardian trustee to administer, as opposed to the sister.
Sure.
So and so there's certain rules about the house and things like that. So the Administration Act is there, but for most people it's not a very good solution. I mean, you want to be able to do things while you have some control of the situation.
Well,
John.
it's a little bit like that old bumper sticker that said, if you don't know where you're going, you're liable to wind up somewhere else.
Mm-hmm.
And that's the truth with wills as well. If you want to know where your property is going to go and you want to direct where it's going to go
Say
after
so.
you've gone, you've got to tell people. And the way to do it is in a will.
Okay, now let me stop you right here because you're the guy who goes to court the most in this tag team, and a lot of what you do is challenging wills, challenging the validity of wills, the inclusion or exclusion of some beneficiaries, and stuff like that. So I have to go back to square one and talk about who does the will, because Canadians, we're a bit cheap, you know, and every chance we get to go for a bargain, we'll go for it. And some well-intended but cheap members of our group will go to the drugstore or somewhere online and buy a DIY, as in do-it-yourself, will kit. Are those, John White, the kinds of things that you end up fighting in court more often than those drawn up by professionals?
Well, I wouldn't say more often than those drawn up by professionals, because we see those as well. But those do-it-yourself will kits, whether bought at the drugstore or acquired over the internet, are a wonderful source of litigation for people like me, because there are things that those kits don't cover that are relevant to the law as it is in British Columbia, which in many respects is different than it is in the jurisdictions where those documents are written.
Ah, okay.
You get what you pay for. It's like anything else.
Right. So,
Could I just want to add one
absolutely,
point to
sure.
the other problem is that there are, there's a BC company that does do the wills
Mhm.
kits, and they provide fairly extensive instructions. However, probably about 40% of the people who buy these kits don't follow the instructions as well. So they don't have the will properly signed, or so in a way it's been not only a waste of money for them, although maybe now under testamentary document John will talk about that later, can be
Okay.
restored. But considering, what it costs, I mean, wills are not that expensive to do.
That was my next question. Typically, guys, how much would a person
Well-
with and I know you don't like the adjective, but with a simple will in mind, a fairly uncomplicated middle-class person, what would it cost to put a will
Well, I
together?
don't want to give you an actual amount. I
Okay.
mean, the fee will be
Under
reasonable.
$1,000?
Well, yeah, probably. And
Okay.
but you see, the problem is when you go see a lawyer to do a will, in some ways it's like a legal checkup too. So, for example, if someone comes to see me with a will, we'll check the land titles. And sometimes we find there's a mistake in land titles where the property doesn't show joint tenancy, which means that we try to correct the title, or there may be an ancient mortgage that they paid off in 2002, but instead of registering the discharge in land titles, they burnt it.
Oh.
So it's
And people do that.
they do
a
that,
mortgage
or-
burning party can be kind of a fun event.
or else they may have a company that's not restored. So it's a way that it's like having a checkup only with a lawyer as opposed to doctors. So sometimes there's things we can detect, and we talk about other things like, which is not like powers of attorney and so forth. So it's a part of an overall plan to get things under control, which makes things easier for yourself and easier for family members as well.
Right, and John White, this is where the whole matter of estate planning comes together with wills, right? Because you are, when you draw up a will, you are in fact planning your estate, aren't you?
Well, you should be. Yeah, I mean that's the whole concept. You're planning for what happens to your assets when you're no longer around to direct what happens to them. And a will is part of that estate plan, but as John said, there are other aspects that you might want to look at as well. And so it's difficult to predict what that process will cost, because it's difficult to predict what the lawyer is going to be doing.
Right, but in the process, as opposed to something you're going to get online or at the drugstore, in the process of sitting down with a lawyer, a professional, to do it properly, first and foremost, so you get it right the first time, but also you're going to have a long explanation of all of the details of your life. And in the course of that, you get a few things sorted out, don't you, John Lakes?
Well, not only that, but you give remember, the lawyer only gives the advice.
Right.
The client gives the choice. And if we say you should do A, B, C, and D, and we can give a breakdown as the price, and if you only choose to do A, that's your choice.
Right.
And as lawyers, the one thing we do want to make sure, though, if you don't do things we advise you to, then we'll make sure it's clear in writing to say that if you don't do it, we don't proceed. Furthermore, there's a thing called lawyer referral where you can phone up and you can make an appointment with a lawyer for a half an hour for $25 with no commitment either way. And it's sort of like a legal dating service.
Okay.
And then you may decide you like the lawyer, you may not like the lawyer. And but they will at least give you the opportunity to make the decision. But when you're talking about people with $1 million, if you've had a house in the Lower Mainland,
see, that's it, isn't it?
and they're
eh?
willing to spend more money on a bath mat than they will seeing legal advice. I mean,
Right.
it's
See, that's the uniqueness of this marketplace. This in Toronto too, John White, is the fact that people who have planned even reasonably well, not even meticulously, but reasonably well, got the house back in the 60s or the 70s or the 80s, paid it off in 25 years. It was, they bought the darn thing for a couple $100,000. Now it's worth 2 point something or other million. And that's the perfect game plan according to the Vancouver Guidebook. But it's suddenly $2.5 million that perhaps in your senior years is a little overwhelming unless you sit down with a lawyer and sort it all out.
well, it's not just that; it's also RSPs, and somebody who, if you have a teacher who's been teaching for 40 years and all of a sudden they die after 1 year retirement, all of a sudden their pension could be worth hundreds of thousands of dollars.
Sure.
So there's they live a very modest life, but don't realizing they're on paper they're worth a lot of money.
But
And-
the members of their family, John
Yes.
White, are keenly aware of the value of that estate.
Oh, I think that's highly likely. Some people sell themselves short. They don't realize because they've lived a frugal and reasonable life.
As your partner was just describing, yes.
That's right.
Because that's the way they were brought up, and that's the way it's been most comfortable. And if they end up with a big whack of change in the bank, that's great, but life has been lived the way I wanted it to. But there are those other family members going, yes, and in the process, you managed to stash away a room full of cash.
Well, that's what makes these cases, in fact, that's what drives so many of these cases. These beneficiaries realize that there is an awful lot of money or an awful lot of wealth stored away, which they'd like to see come to them, or as much as possible come to them.
Sure.
Unfortunately, that can lead to strife within families, and it does lead to litigation from time to time as well.
And of course, if there's turmoil, competition among siblings is pretty standard form in any family. But if there's competition before the patriarch passes on, it's likely that it's going to become that much more intense, if they're particularly in the absence of a perfectly crafted will.
Well, uncertainty just opens the door for these conflicts to really flare up and to become even more intense than they would be while the patriarch is still around.
Right, right. We're talking lawyers and wills and estates and planning, and there's just so much more to talk about. We'll take a quick time out here, or our producer is really going to be angry at us, and he's the one with all the good music. So we'll hear more of that after this break.
There's more of the show still ahead. This is The Law Show on CL 650.